Hello friends, I welcome you all to lecture number 5 of Indian Partnership Act, which is a part of CA series. I'm your mentor Shekhar Galot. These classes have been sponsored by Sri Jayendra Rank Zone. So we are now on the later parts, ending parts of the Indian Partnership Act. But just don't assume that because these are ending parts, these are not important. Now the coming portions are as relevant as any other portion of the Indian Partnership Act, and in fact, I will say they are much detailed and are much asked after in the exams usually. So do pay your required attention, do pay a committed attention to the lecture we are going to begin right now. So now this time we will begin with legal consequences of partner coming in and getting out. Like we discussed, just like a phone call, we have a incoming partner and an outgoing partner. So what are the legal consequences of an incoming and outgoing partner? Okay, we'll study now. So just have a look and we will start our discussion within a minute. Any change in relation of partners, okay, any change in relation of partners will result in reconstitution of the partnership firm. Thus, on admission of new partner, or retirement of a partner, or expulsion of a partner, or on insolvency of a partner, etc., etc., a firm will be reconstituted. Reconstitution means will come into picture afresh. Okay, afresh. That means a new partnership. A new partnership will come into place. Okay, when I say a new partnership will come into place, I am not saying that the partnership will dissolve and the new partnership will come into place. No, it is simply because A, B, C, D were the partners. Now they are going to be A, B, C, D, E, or A, B, C. Okay, they are going to have a new phase, new reconstitution of the partnership. It means partnership will have a different shareholding pattern, a different profit sharing pattern, and will have definitely different assets than it had earlier. Either the assets are going to multiply or the assets are going to be divided. Assets are going to be less in number because of the partner has gone out and no new partner has joined in. So any change in relation of partners will result in reconstitution of the firm. And what type of changes could it be? Okay, what type of changes could it be? Thus, the admission of a new partner is a change. Retirement of a partner is another instance. Expulsion or insolvency of a partner, etc. That means there may be other situations as well, okay, of similar nature. Okay, so in these situations, the firm will be reconstituted. Its constitution will again become changed. It will become a fresh constitution again. Introduction of a partner. Section 31 says, subject to contract between the partners and the provisions of Section 30, no person shall be introduced as a partner into the firm without the consent of all the existing partners. Now, without the consent of all the existing partners, that means unanimity has to be 100% consent. Without 100% consent, no new partner could be brought in. But this is also subject to contract. Subject to contract between partners. This is subject to contract between partners. Okay, if the partners have agreed that there is one managing partner who is looking after the firm, who is holding the reins of the firm. He alone shall decide if a new partner has to be admitted or not. If he decides it has to be admitted, we are okay. If he says no, we are okay with that as well. Okay. So if as per the contract, the power has been given to one or two partners or three partners, okay, then those one to three partners shall decide it. The consent of all those one to three partners shall be mandatory. If it says only one partner, then the consent of managing partner will be sufficient. But the law says, in case there is no such provision in the contract, in the partnership deed, there is no such clause which permits the entry of a new partner, then ultimately, if the new partner has to be added, then it can be added only with the consent of all the existing partners, not majority of partners. Okay, see, the decision of a firm usually are taken by majority. Okay, decision of the firm are usually taken by majority, but some decisions are there which are not sufficient if taken by majority. Like in the company law we discussed, we have a majority that is more than 50, then we have a special majority that is more than 75. Okay, in partnership there is no special majority, no 75 rule. Either it's a majority or it's a unanimity. Either you have to have majority for some things, for business of the firm, majority of partners voting for favor is sufficient. But when you are going to add new partner, then definitely you are going to change the nature of the business from cricket to real estate. These are some fundamental changes in the partnership. Okay, so when you are going to make a fundamental change, if you are going to make an incidental change, okay, a small change or a minor change or a change which is required to update yourself or your partnership with the time, then you can do it with the majority rule. Out of five partners, three partners say a thing, then a thing would be done. But this is a fundamental change. You are going to add a new partner, and the delicate nature of partnership, which is based upon the mutual trust, confidence, and faith between the partners and their acquaintance with each other. So, the delicate nature of the partnership, if you bring a new partner, it is a fundamental change in the partnership, reconstitution of the partnership, the act says. So, in this case, for fundamental changes, consent of all the partner is required. Okay, so it has to be a unanimous consent here. Subject to the provision of Section 30, a person who is introduced as a partner into a firm does not thereby become liable for any acts of the firm done before he becomes a partner. So that is a very general rule and a reasonable one as well. It says when a new partner is entered into the firm, he automatically will not become liable to whatever firm has done till today. Okay, suppose he joins today, he joins on whatever date. So whatever liability the firm has acquired before him becoming a partner, okay, this liability shall not automatically transpond upon the new partner as well. Okay, he won't be personally liable for whatever the firm has decided before he joined the firm. Okay, that is reasonable as well. Now, what are rights and liabilities of a new partner? Now, we are discussing that we can have a new partner. How we can have a new partner by consent of all. Okay, and what is the now? Let us understand the incident legal consequences, because the heading is legal consequences of partner coming in and going out. Now, here the partner is coming in. So, what are the legal consequences, legal issues, okay, which will happen when a new partner joins in? Okay, the liability of the new partner ordinarily commences from the date when he is admitted as partner, like this particular subclause 3. Okay, ordinarily, it says ordinarily the liability will comment from the date he joins as a partner, unless he agrees to be liable for obligations incurred by the firm prior to the date. That means if he wishes to, ordinarily, the law says we will not make you liable for whatever has happened before your joining. But if you want to take that liability as well, you want to support the firm in that case, then you can. if he chooses to make himself liable for the acts done by the firm prior to his joining, then he can do so. That is his personal choice. The new firm, because there is a reconstitution. Okay, a kind of new firm has come into picture, because earlier the firm was ABCD, now it is ABCDE, or if someone has gone ABC. The new firm, including the new partner who joins it, may agree to assume liability for the existing debts of the old firm. Okay, so you understand the difference between the term new firm and the old firm. When we use the word new firm, it does not automatically mean that the old firm has dissolved, old firm has liquidated its assets. Okay, and now there is a new firm coming up, completely new firm right from today. No, this is not happening. The old firm is continuing, but because there is a reconstitution in the partnership, okay, in a symbolic manner, we call it a new firm. Okay, otherwise everything is same as it used to be in the old firm. Just the simple changes, the partners has have changed, partnership has changed, shareholding pattern has become different now. Okay. The new firm, including the new partner who joins it, may agree to assume the liability for the existing debts of the old firm, and creditors may agree to accept the new firm as their debtor and discharge the old partners. The creditor's consent is necessary in every case to make the transaction operative. Novation is technical term in contract for substituted liability, of course, not confined only to the case of partnership. Now it says a very important thing, that suppose there is a new firm. Okay, now there is a reconstitution. Okay, and new firm has come up. Okay, symbolically, let us say that new firm has come up. I again state that this new firm is not that everything has changed, there is a new name and this and that. No, only on reconstitution it's a kind of a new firm because of reconstitution. So new firm will discharge the liabilities taken by the old firm. Okay, they will continue to discharge the liability. That is reasonable as well. Okay, they have to. But if creditors say that it's okay from today onwards, the liability of the old firm is transferred to the new firm, and now you are our new debtors. Okay, you are now our new debtors. From today, you are our new debtors. Okay, then that also can happen if they want to give new name to the firm. Okay, if they want to give the new name to the firms, everything new, then that also can happen. That is called novation. Novation is a technical term. Okay, it is just a part of innovation. That means something new is happening in the contract. You understand innovation? You are inventing something new which is scientific and industrially usable. Novation simply in the terms of contract is a technical term which means something new has happened in the contract. A new clause has been added, or a kind of modification, alteration in the contract, already existing contract. Okay, in the already existing contract. That is the technical term is novation. But a mere agreement among partners cannot operate as a novation. Thus, an agreement between the partners and the incoming partners that he shall be liable for the existing debts will not ipso facto give creditors of the firm any right against him. Okay. An agreement between the partners and the incoming partner that he shall be liable for existing debts will not automatically give the creditors of firm any right against him. Okay. Why? Because creditors don't have any such contract with the new partner. He has not, the new partner has not entered into any contract with the creditors that I have to pay some money to you. It is only an arrangement between old partners and the new joining partner. Creditors will still run behind the old partners, and old partners can rope in the new partner, can ask the new partner that because we have an agreement, you would share the liability, now share the liability. This new partner is bound by contract with the old partners to fulfill the liability of the firm. Okay, but he has no such agreement with the creditors who are already the creditors of the firm. Okay, they are not new creditors, they are already creditors. So he has no liability to them. So if he has a agreement with the partners that I will be liable for the other partnership as well, for the previous debts of the firm as well. It does not automatically give any right to these creditors to chase him. Okay, that's it. They can still have a right to chase these partners, and these partners can then in turn chase this partner. This is the cycle. Okay. In case of partnership of two partners, suppose now we are discussing a partnership, we discussed a partnership A, B, C, D. Okay, there were four partners, or there may be, usually there are 10, 20, 40 partners in a big partnership. But let us take the case of a very small partnership, which is just a partnership of two people, usually two brothers, or or husband, wife, or brother, sister, or two friends. Okay, usually small partnerships are partnerships of two people. This is the smallest partnership in law we can have. In case of partnership of two partners, this section does not apply to a partnership of two partners which is automatically dissolved by the death of any one of them. Because this section is not applicable to a partnership of two people. Okay? Because there are just two people. When another one dies or retire or expelled or dismissed, the partnership will automatically come to an end. Okay, the partnership will automatically come to an end. You cannot continue a partnership which was originally between two people and now half of that partnership is gone. Okay, so what is left in the partnership now? Only this clause is applicable when you are having more than two partners. Multiple partners are there, like 5, 6, 7, 8. 8 partners are there, 7 are still there, one is going. Then we can still say that the partnership is going on. 7 people are there, one more is added. But now one and one only two people are there. One of them is leaving, or one of them is retiring, or is dismissed, or anything happens. The firm will definitely go for liquidation. Okay, because he will take half of the firm when he will leave, as he is having half share in the firm. So this clause is not applicable to people where only two partners are there. Retirement of a partner, that is section 32. A partner may retire. Now we discuss how a partner of a firm may retire if he wishes to. A partner may retire, first of all, with the consent of all other partners. That means law does not even allow a partner to retire peacefully because you have assumed the responsibility of a partnership, and partnership is such a relation that you cannot run away whenever you want to. There may be some liabilities which you have to discharge. Okay, there may be some contracts which you have to fulfill. So you cannot leave the partnership at your will whenever you want to. Okay, so you can retire only with the consent of all other partners. All other partners, not majority as well. Okay, here as well, because this is a, like we discussed, going out of a partner or coming in of a new partner is a fundamental shift for a partnership. So whenever there is a fundamental shift or fundamental or groundbreaking change, then you need the unanimous consent of all the partners involved. In accordance with an express agreement by the partners. He may retire with the consent of all other partners, or in accordance with an express agreement with the partners. Suppose your partnership agreement when you entered into partnership deed, it had a retirement clause. It had a retirement clause. It said partner on attaining 70 years age shall retire. Okay, there may be something like this. If you have such a clause, that means now you are retiring in accordance with the express agreement. Or where the partnership is at will by giving notice in writing to all the other partners of his intention to retire. Now, this is a case of partnership at will. We discussed a partnership at will is partnership which will go on till the time you want it to go. Okay, if you want it to come to an end, it will come to an end. So this is the partnership which will go on at will. So if it's a partnership at will, you do not need the requirement of the you do not need the consent of the other partners because it's a partnership at will. So you can just retire by giving a simple notice to public as well as to the partners that I am retiring, and you have to give a reasonable notice. It does not mean you can retire any day you want. You'll have to give them a month or a 2 months notice. So, in order to allow them to settle the accounts and to settle your liabilities qua the partnership. A retiring partner may be discharged from any liability to any third party for acts of the firm done before his retirement by an agreement made by him with such third party and the partners of the reconstituted firm, and such agreement may be implied by a course of dealing between the third party and the reconstituted firm after he had knowledge of retirement. Okay, that means if a retiring partner had some liability, like suppose say firm has to pay 50 lakh to X. There are 10 partners having equal share. A wants to retire. He pays 5 lakh rupees to X as part of his share of the contribution in this 50 lakh rupees. Okay, firm owes 50 lakh rupees to X. Okay, so there are 10 partners. So technically it comes down to 5 lakh each. But I am again making it clear that X has a choice. He can ask all 50 lakh rupees to from A, or he can ask 5 lakh rupees individually, or he can ask 10 lakhs each from 5 of the selected partners. He has a choice. There is no rule because partners are jointly as well as severally liable. So X can run after only one partner if he wants to. So now A strikes a deal with X and says my contribution would definitely ultimately come down to 5 lakh rupees because we are 10 partners of equal share. So I pay you 5 lakh rupees and you discharge me. X will have a new agreement with firm and agree to discharge A from his all liabilities towards X. Okay, this could be done. This could be in writing as well as this could be implied. So yes, everything can happen in an implied manner as well. We have discussed a lot of times. There is no requirement for everything to be in writing, especially when this is an agreement. This is just an agreement between X and the new firm. So there is nothing which prevents an oral agreement from happening in the Partnership Act or in the Indian Contract Act. There can be a lot of oral agreements. So there may be an agreement oral which can be implied from the course of dealing. Okay. Notwithstanding the retirement of a partner from a firm, he and the partners continue to be liable as partners to third parties for any act done by any of them, which would have been an act of the firm if done before the retirement, until public notice is given of the retirement. Okay. So we are talking about two type of liabilities now. Okay. A liability, two liabilities are liability assumed by the firm before retirement of A. before this A is a partner, before A retired, whatever liabilities firm had assumed, whatever liability firm had taken over before his retirement will continue to run against him. That means A shall remain liable. Even after his retirement, A shall continue to be liable for all the liabilities which the firm undertook when he became a partner, when he was a partner. Second liability is liability assumed by the firm after retirement of partner of A but before giving public notice. Suppose he has given the public notice, he retired from the firm and he gave the public notice after 6 months. There is a gap of 6 months, say, assume there is a gap of 6 months between actual retirement and the actual date of proper public notice. Okay, we are not talking about public notice alone, but a proper public notice. There is a gap of 6 months. Now, within those 6 months, if the company has assumed any liability, okay, then this partner A who has retired will continue to be liable. Even though he had actually retired when the liability was assumed. That means now you understand how important a public notice of retirement, and that too a proper public notice of retirement is required, is mandatory for a partner who is retiring from the firm. Otherwise, firm may incur any liability and he will continue to remain liable. So it is very important for a partner that before he retires or when he retires, he should issue the proper public notice on the same day of his retirement so that to avoid any further legal consequences which may come back to haunt him later on. Provided that a retired partner is not liable to any third party who deals with the firm without knowing that he was partner. Okay, only clauses that if any party, a new party comes to deal with the firm who does not know that A was a partner, then A will not be liable. Okay, but usually same parties come back to do business again and again with the firm. So A will run a risk if he does not give a proper public notice of retirement. Notice under subsection 3 may be given by the retired partner or by any partner of the reconstituted firm. This notice may be given either by the partner A who is retiring or by any of the partner of the reconstituted firm or by the firm that this partner A has retired. We wish him a great health and a great life ahead. Something like this. Okay. So it may be given either by him or by the firm. Anyone can give it. A partner is set to retire when he ceases to be a member of the firm, without bringing to an end the subsisting relations between the other members or between the firm and third parties. Okay, that means he has retired. Okay, without bringing an end between the relationship between the other members or between the firm and the third parties. That means firm is not dissolved. Firm is still continuing. Okay, but only he is retired. The term does not cover the case where a partner withdraws from a firm by dissolving it. Okay. Retirement does not cover a case in which the partner has withdrawn from the firm by dissolving it. Okay. That will be a dissolution of the firm. That will not be retirement. Retirement means you have retired. The other entity, the entity which is the partnership, will continue. But if the partnership is dissolving, so you are not retiring. That means your partnership has come to an end. Okay. So the term retirement does not cover the case where a partner withdraws from a firm by dissolving it, which should properly be referred as a dissolution and not as a retirement. Retirement of a partner from a firm does not dissolve it. Retirement will not dissolve it. Okay, and this retirement thing is not applicable on the partnership firm which has only two partners. Okay, in that case it will dissolve the firm. But here, if there are more than two partners, multiple partners, if one partner is retiring, the firm will not get dissolved. Vishnu Chandra versus Chandrika Prasad, that is a Supreme Court decided case law. Okay, let us see what Honorable Court has observed in this. The Supreme Court in Vishnu Chandra versus Chandrika Prasad held that the expression, if any partner wants to dissociate from the partnership business, in a clause of partnership deed which was being construed comprehends a situation where a partner wants to retire from partnership. The expression clearly indicated that in the event of retirement, the partnership business will not come to an end. Okay, there was a issue before the Supreme Court that one partner had retired. Okay, there were more than two, three partners. One partner had retired, and there was a case. Other partner said that firm has already dissolved because of the retirement of a partner. Okay, and there was no such clause in the partnership deed. So Supreme Court said because there was a clause in the partnership deed which read, if any partner wants to dissociate from the partnership business, Supreme Court said that this clause was a proper indication that partnership deed had a retirement clause. So when a partner had retired, the firm will not come to an end. Okay, the firm will not come to an end because it's a retirement, it's not a dissolution of firm. Dissolution of firm. Now, what are the liabilities of an outgoing partner? As we have already stated earlier, a retiring partner continues to be liable to third party for acts of the firm after his retirement until public notice of his retirement has been given either by himself or by any other partner. Either he has given the notice or any other partner has given the notice or the firm has given the notice. Either way, the notice could be given, but if no notice has been given by any of these and he has retired, then also he will continue to be liable, but only in those cases in which the party believes that he is a partner. Okay, but the retired partner will not be liable to any third party if the latter does deals with the firm without knowing that the former was a partner. This is a case of when some new party comes to deal with the firm which does not know that there was earlier another partner as well which has retired now. So, in liability of that case, he will not be liable. The liability of a retired partner to the third parties continues until a public notice of his retirement has been given. As regards to the liability for acts of the firm done before his retirement, the retiring partner remains liable for the same, unless there is an agreement made by him with a third party concerned that the partners of the reconstituted firm. Okay, that whatever liabilities he or the firm assumed when he was a partner, he will continue to be liable for those. Okay, even after his retirement. And how he can run away, how he can evade, sorry, not evade or run away, but how he can prevent those liabilities from running against him is by having an agreement with the third party, and then the third party will have an agreement with the new firm that we discharge your earlier partner, okay, from this liability. This way he can seek a discharge, otherwise he'll continue to be liable for whatever liability the firm has assumed when he was a partner. Such an agreement may be implied by course of dealings between the third party and the reconstituted firm after he had knowledge of the retirement. If the partnership is at will, the partnership, by giving notice in writing to all the other partners of his intention to retire, will be deemed to be relieved as a partner without giving a public notice to this effect. Okay, if the partnership is at the will, then if he has given notice in writing to the other partners, then he can retire and he is not required to give a public notice for this effect in the case of a partnership at will. Expulsion of a partner. Now a partner, we are discussing cases of partner going out. Now partner can go out in different ways. He can retire, okay, or he can be dismissed. Expulsion means dismissal, termination, okay. Dismissal or termination. That means forceful eviction of a partner. Okay, forcefully, one partner has been forcefully or legally, okay, by majority of partners, this partner has been thrown out of the firm. What will happen if such a partner, if a partner is expelled from the partnership firm? Let us see. A partner may not be expelled from a firm by any majority of the partners, save in the exercise of good faith of powers conferred by the contract between the parties, between the partners. He, one partner, once a partner, forever a partner. Okay, but there is a exception to this rule. A partner can be removed or expelled or dismissed from the partnership by the majority of partners. Okay, by the other partners, majority. It is majority, not unanimity. It is expelled for dismissal. It is majority of parties, but only and only in good faith. Good faith means their action should be reasonable. Okay, their action of expelling this partner should be reasonable and fair. They should not do any injustice to the partner. It should not be that you form a majority of partners and then you do injustice to any partner and you remove anyone from the partnership you want to. No, this is not the case, but it can be done only in good faith. Okay, the provisions of subsection 2, 3, 4 of section 32 shall apply to an expelled partner as if he were a retired partner. Subsection 2, 3, 4 of 32 are dealing with the liabilities of a retiring partner, that he will continue to be liable. So, same is applicable to a dismissed partner as well. Okay, even if a partner is dismissed, he will continue to be liable for the acts done by him or the firm when he was a partner. Okay, and if he has not given a public notice that I have been removed from the firm, then also he will continue to be liable for the liability assumed by the firm after his expulsion and before giving his public notice. Let's do an example. A, B, and C are partners in a partnership firm. They were carrying their business successfully for the past several years. Spouse of A and B fought in ladies' club on their personal issue, and A's wife was hurt badly. Now, A, B, C are partners. A and B's wife fought in ladies' club, and A's wife is hurt badly. A got angry on the incident. He convinced C to expel B from their partnership. Now he convinced C because the majority can expel. Now A and C they form majority. B was expelled from the partnership without any notice from A to C. Considering the provisions of Indian Partnership Act 1932 state whether they can expel a partner from the firm or not. Now they are in majority. Okay, the Partnership Act says a partner can be expelled, okay, from the partnership by the majority of partners. Now A and C are majority and they have dismissed this person B from the partnership. But what is the reason of dismissal? Dismissal is the ladies or the wives of A and B fought and A's wife was hurt badly. Now is the dismissal of a partner on this reason justified or not? Let us see the answer. A partner may not be expelled. Okay, a partner may not be expelled from a firm by majority of partners except in exercise of good faith of powers conferred by the contract between the parties. Okay, it says that only in good faith you could expel someone. Okay, so in this case there is no good faith at all. It cannot be a sufficient reason that because wives have fought, we will remove someone from partnership. Okay, in this case, the expulsion of B is not justified as it is not based on good faith. Good faith, rather on bad intentions. Okay, just to take a revenge. It's this termination is full of vengeful. Okay, just to take a revenge. The power of it's 2 o'clock. Now, before using the power of, before majority uses a power of expulsion over another partner, let us see how this power has to be used. The power of expulsion must have existed in the contract between the parties. Now, it existed in the contract, that means we are talking about a written contract. Usually, if you are trying to find these powers, you cannot simply rely on the oral contract. Okay, you have to have a written contract, and when you have a written contract, then you can say that the contract provided us power to expel. The majority could have expelled other partner. So this way, a partner has been expelled. The power has been exercised by a majority of partners. Okay, that such power has been exercised by majority of partners. Majority of partners. Okay, it is not that a managing someone has become a managing partner. Okay, it is not that in a firm of 10 partners, one partner is working as a managing partner and he is taking the crucial decision. He someday comes off and he takes a decision that P is expelled. No, this is not what the type of majority we are discussing here. Okay, this is not the majority we are discussing. Okay, we are not talking about a partner who's more powerful than others. We are talking about a majority of partners. That means if a firm is 10, then at least 6 have to be there. It has been exercised in good faith. If all these conditions are not present, the expulsion is not deemed to be in bona fide interest of the business of the firm. Okay, if any of this condition is not present, okay, all three conditions should occur simultaneously. That at the same point of time, all these four conditions should be there. If any one of this condition is not fulfilled, then it shall be deemed to be a bad expulsion. Thus, according to a test of good faith as required under section 33(1), expulsion of partner B is not valid. Okay, because there is no good faith. In this context, you should also remember that provision of section 32(2), 3, 4, which we just discussed will be equally applicable to an expelled partner as if he was a retired partner. That means he will be liable if it does not give a public notice or the firm doesn't give a public notice. Insolvency of a partner. Now a partner. Now we know two ways in which a partner can leave a firm or can be sent out of the firm. First one is retirement. Then the other one was dismissal or expulsion. Now comes the third one. This is another way of a partner going out of the firm. That is insolvency of a partner. Section 34 deals about insolvency. You know what is insolvency? When a person has become insolvent. When a person becomes insolvent, when his assets are less than his liabilities. That means he has to pay 100 crore. So he has to pay 1 crore rupee to the people, but he is having only 50 lakh rupees. So now he is falling short of 50 lakh. That means he has now become a bankrupt. Okay, he has become bankrupt. Where a partner in a firm is adjudicated and insolvent, he ceases to be a partner on the date on which the order of adjudication is made, whether or not the firm is hereby dissolved. Now, who will decide that someone has become insolvent? Okay, it is not simply a case that I issue a check to you and the check is bounced, and the reason for bouncing of the check is insufficient funds. Simply merely not having sufficient funds in my account will not render me insolvent. Or if I have taken some loan, okay, and I am not able to repay one or two installments, just because I am not able to pay one or two installments, I will not be declared insolvent. You cannot call me insolvent or a bankrupt. Okay, when can someone call me a bankrupt? when after a proper adjudication, when this proper case, court case, and after court case, court says that this person is adjudged, as adjudged means judging, okay, some person is judged, judge says that this person is insolvent, declared insolvent, then only we can call someone an insolvent or an bankrupt. That means it's a legal act, okay, and could be done through court of law only. It does not mean that if I am not able to pay my money to someone, automatically you will declare me insolvent and throw me out of the firm. No, this way it doesn't work. Okay. Now it says when a partner is adjudged insolvent, he ceases to be a partner on which date? On the date such order is passed. On the date he becomes ineligible to be a partner because he can no longer continue into an agreement or a contract, because insolvent person is incapacitated, has no capacity to enter into a contract as per the provisions of the Indian Contract Act, and as per the Partnership Act. The partnership arises out of an agreement or the contract. So when you cannot have an agreement or the contract, you cannot be a partner at all. So the date you are adjudged, a judge says that you are declared bankrupt or insolvent, you will cease to be a partner. Okay. Where, under a contract between the partners, the firm is not dissolved by the adjudication of a partner as an insolvent. The estate of a partner so adjudicated is not liable for any act of the firm, and the firm is not liable for any act of the insolvent, done after the date on which the order of adjudication is made. It simply says that in case, suppose the firm is a firm of more than two partners, like there are 7 8 partners, suppose 10 partners are there, one of them is adjudged insolvent, one of them is declared bankrupt, the firm will continue, okay, he will simply walk out of the firm, and this will be treated like just like a case of retirement, and the firm will keep continuing its business with now rest of the partners left. Okay, so the firm will not dissolve. But when in this case a firm does not dissolve, then the firm shall not be liable for whatever actions his insolvent partner takes after his dismissal from the firm, or this insolvent partner will not be liable for whatever liabilities the firm will assume after his dismissal due to insolvency. Okay, so there will be no liability at all between each other. When a partner in the firm is adjudged and insolvent, he ceases to be a partner on the date of the order of adjudication, whether or not the firm is thereby dissolved. His estate, which thereupon vests in the official assignee, ceases to be liable for any act of the firm done after the date of the order. And the firm is also not liable for any act of such partner after such date, whether or not under a contract between the partner the firm is dissolved by such adjudication. Liability of estate of deceased partner. Now, what is the now? Suppose now there is another case now. Okay, this is another situation. Now we have discussed 3 situations. Okay, how can a partner go out? A partner can go out after taking retirement, or he is expelled, or he has been adjudged insolvent. But now there is a fourth case after death. Okay, death automatically results in retirement of a partner, permanent retirement of a partner. Okay, so if a partner has died, that means he has automatically ceased to be a part of the partnership. Okay, so when he has automatically ceased to be a part of the partnership upon his death, okay, so now he is no longer liable, but okay, the firm had some liabilities. Okay, and he was a partner and he died. Death is in nobody's hand, but you have to pay your liabilities. When he has died, who will pay the liabilities which he was supposed to pay? Let us read the liability of estate. Estate means whatever property he had. Estate of a deceased partner. Where, under a contract between the partners, the firm is not dissolved by the death of the partner. The estate of deceased partner is not liable for any act of the firm done after his death. That means, that means, that means though the partner has died, but the liability will continue. Okay, though the partner has died, but when he was a partner, when he was alive, the firm had assumed certain liabilities, and now when he has suddenly died, so whatever property this person has left, this partner has left, okay, that property will be liable. That property will be liable for the debts or the liabilities of the firm which were assumed when he was living. Okay, so liabilities assumed during his lifetime shall keep running against his property even after his death. Ordinarily, the effect of death of a partner is the dissolution of partnership, but the rule in regard to the dissolution of partnership by death of a partner is subject to a contract between the parties, and the partners are competent to agree that death of one will not have the effect of dissolving the partnership as regards the surviving partners, unless the firm consists of only two partners. If there are only two partners, then automatically upon death the partnership firm will be dissolved. But if there are more than two partners, 3, 4, 5, 6, 7, 8, and any number till 50, okay, 50 is the maximum number of partnership. If there are more than that partners, then they can have an agreement that tomorrow if someone dies, unfortunately, if someone dies, then the partnership will not automatically come to an end and partnership will keep on continuing without that particular partner. That is possible. Okay, but you have to have a contract for that. If you do not have a contract, then partnership will come to an end. In order that the estate of the deceased partner may be absolved means freeing, discharging. Absolved means free up from liability for the future obligation of the firm. It is not necessary to give any notice either to the public or the persons having dealing with the firm. There is no requirement of giving the notice because a dead man cannot give a notice. Okay, when someone has died, how can he give a notice? Yes, firm can give the notice, but it is upon the firm whether they give the notice or not. Okay, firm may not give a notice. So when the firm will not give a notice, if you make the this real estate of a dead partner liable just because firm did not give a notice, that will be a grave injustice to someone who has died. So in this case, no public notice is required. A dead member cannot give a notice, and firm may or may not give a notice tomorrow. So we cannot make him liable for the actions of the firm. Okay. Rights of outgoing partner to carry on the competing business. Now we have done the liabilities of the outgoing partner, and we have done four situations in which a partner can go out of the firm. Okay, now these were the liabilities. But now let us see what rights he have. Does he have any right at all? Let us see. Okay, give it a reading, and we shall reassemble within a minute or two. Okay, let's come back. Rights of outgoing partner to carry on competing business. That is now section 36. An outgoing partner may carry on business competing with that of the firm and he may advertise such business but subject to the contract to the contrary. Contrary means opposite. Contrary means opposite. So he can carry on the competing business. Now I have a partnership. I am in a partnership. Suppose we are four partners. We are selling onions or we are selling sugar. Okay, now I have retired or I have gone out, I have been expelled, I have been dismissed. Okay, either way I have come out of the firm. I have not died though, okay, I am alive. Okay, so I have come out of the firm. Now I can carry on the sugar business. I can now myself have a independent sugar or the onion business or just say similar business, identical business which I was carrying on when I was a partner in the firm. But this right could be restricted. Okay, this right could be restricted if there is a contract between me and the firm. When I joined the firm, if there was a contract that I cannot carry on this particular trade if I retire from this firm, then I could be reasonable restrictions could be put upon me. Okay, he may not, but definitely he cannot use the firm name. Okay, because he is no longer a partner, so it would be illegal for him to use the name of the firm because in that case he is going to cause a bad reputation to the firm and he people will believe that he is still a partner of the firm. He will ultimately give a lot of liability to the firm. Represent himself as carrying on the business of the firm. Definitely he cannot do so when he is retired. Solicit the custom of persons who were dealing with the firm before he ceased to be a partner. Okay, he cannot try to fish, that is called fishing. Okay, he cannot try to fish for the or fishing or poaching. Okay, he cannot chase the already existing customers of the firm. Suppose when he was a partner of the firm, he came in contact with 4 or 5 people who gave good business to the firm. Now after retiring, he is going to them, he is reaching to them and he is saying, now you do business with me and I'll give you a discount. Why he cannot do that? Because he is confidential. He knows the confidential dealing between the person and the firm. He knows the rate and he knows everything. So he can now manipulate, he can now give the discounts which the firm otherwise would not have given. Why? Because firm is having a good position. So when the firm is in a good position, someone, a company or a firm in a good position usually do not offer much discount. But someone who's starting afresh can do same thing on less money basis. Okay. So this is also not allowed. He cannot do that as well. Agreement in restraint of trade. A partner may make an agreement with his partners that on ceasing to be a partner, he will not carry on any business similar to that of the firm within a specified period or within specified local limits, and notwithstanding anything contained in Section 27 of the Indian Contract Act, such agreement shall be valid if restrictions imposed are valid and reasonable. We have discussed this when I discussed it with you in some previous classes about, and I discussed especially the case of a Savana Bhav. Okay, because that is, you people will be more able to understand Savana Bhav because it's a very famous restaurant chain in Tamil Nadu. Okay, so when I cease to be a partner of Savana Bhav, I leave Savana Bhav, I was a partner. I cannot use the name of Savana Bhav. Plus, there can be restriction. They can say because we are popular in Tamil Nadu and you know our customer base and you know our way of dealing. So you can take illegal advantage of the firm or the knowledge which you have gained from the firm. So now you are not allowed to set up a South Indian style restaurant. You can have a burger pizza thing, okay, but you cannot have a idli dosa thing, which is our which is the speciality of Sarvana. Or if you want to sell idli dosa, you go to the Gujarat. Don't do it here. Like this. These are reasonable restrictions and they are not against the Section 27 of the Indian Contract Act, which says, which declares expressly all the contracts in the restraint of trade to be void. Okay, but there are exceptions to that thing as well. Rights of outgoing partner in certain cases to share subsequent profits. Okay, please give me 2 minutes break. Rights of outgoing partner in certain cases to share subsequent profits. What is subsequent? Happening after outgoing, happening after retirement. Okay, subsequent means events happening after. So, in certain cases, an outgoing partner can have a share in the profits which a firm will make after the retirement of such person. Let us see in what cases it could be done. According to section 37, where any member of a firm has died or otherwise ceased to be a partner, and the surviving or continuing partners carry on the business of the firm with the property of the firm without any final settlement of accounts as between them and the outgoing partner or his estate, then in absence of a contract to contrary, the outgoing partner or his estate is entitled at the option of himself or his representatives to such share of profits made since he ceased to be partner as may be attributable to the use of his share of the property of the firm or to the interest at the rate of 6% per annum on the amount of the share of the property of the firm. Now this is purely simple thing. Okay, very simple. I'll just explain you with the example. A, B, C, D, E are five partners in a firm. E retires. Now, upon retiring, when E retires, definitely E will take his share back from the firm. Okay, his contribution he will take it. Okay, suppose he is now entitled to 50 lakh rupees upon leaving. E is entitled to 50 lakhs upon retiring. He is entitled to 50 lakhs upon retiring. But what happens? The firm has not settled the accounts. Firm has not settled, not maintained the accounts. Okay, or there is some issue, they are not able to settle the accounts. Firm has not settled the accounts for next 5 years. Then for next 5 years, firm has not paid 50 lakh rupees to him. Then that means firm is using his 50 lakh, isn't it? For the next 5 years, firm is using his property. What is his property? His share. Firm has still not given him his share. He has retired, but firm is still keeping his share. And firm is using his share as well. So when the firm is using the share of the retiring partner or a partner who has died, the firm has not settled the accounts and given the share to the son. Then in this case, till the time the accounts are settled, the firm shall pay the profits, share in the profit to the person who has retired or died, or interest over this 50 lakh rupees at the rate of 6% per annum. Okay, this is by the act. Either firm shall pay him a share in the interest, or firm shall pay him a interest at the rate of 6%, provided that, whereby contract between the partners, an option is given to surviving or continuing partners to purchase the interest of a deceased or outgoing partner, and that option is duly exercised. The estate of the deceased partner or the outgoing partner or his estate, as the case may be, is not entitled to any further or other shares of the profits. But if any partner assuming to act in the exercise of the option does not in all material respects comply with the terms thereof, he is liable to account under the foregoing provisions of this section. It says where there is a contract or an option is given to surviving or continuing partner to purchase the interest of the surviving means son. Okay. Surviving means son or continuing partners or the partners which are now left after his leaving to purchase the interest of the deceased or outgoing partner, and that option is duly exercised. This option is exercised either the son has become a partner, okay, that the son has become the partner, or continuing partners have purchased a share and made the payment. The estate of the deceased partner or the outgoing partner or his estate, as the case may be, is not entitled to any further or other share in the profits. If his son has become a partner, okay, then his estate will not receive any further profits, okay, because now further profits shall be given to his son only, okay, because his share is given to his son, okay. But if any partner, assuming to act in exercise of the option, does not in all material respects comply with the terms thereof, he is liable to account under the foregoing provisions of this section. But suppose if any partner does not comply with the conditions, someone has died and the firm is not giving the share, not letting his son to become a partner, not letting the son to exercise that option, okay, or some partner says I will buy the share but he is not making the payment, then he will be liable to pay at the rate of 6%, or he will be liable to give the share in the profits. Clear? Let's do an example. A, B, and C are partners in a manufacture of machinery. A is entitled to 3/8 of the partnership property and profits. A becomes bankrupt, whereas B and C continue the business without paying out A's share of partnership assets or settling accounts with his estate. A's estate is entitled to the 3/8, okay, because this was his share, of the profits made in the business from the date of the bankruptcy until the final liquidation of the partnership affairs. Till the time such payment is made, his estate or his family member will keep getting that share of 3/8 whatever his share was there. A, B, and C are partners. C retires after selling his share in the partnership firm. A and B fail to pay the value of the share to C as agreed. The value of the share of the C on the date of the retirement from the firm would be pure debt from the date on which he ceased to be a partner. As per the agreement entered between the parties, C is entitled to recover the same with interest. Interest is 6% per annum fixed by the Act. Okay, but if the contract says 12%, it could be 12%, 18, 18, 24, whatever. I mean, you can do a lot of flexible stuff in your partnership deed. Act will not come into your picture unless and until your provisions are seriously very perverse, seriously illogical against the law. Okay, In those cases only the court will jump up. Otherwise, court will keep itself away. Whatever you people have decided, you follow it. No issues. Sorry. Now we go on to registration and dissolution of a firm. Registration is a way of bringing into law, okay, or giving birth to a partnership. That is registration. Dissolution at the same time is like bringing an end to the life of partnership. Okay, so now let's understand how a partnership is given birth and how a partnership is the life of partnership is taken away. Let us understand that this is a flow chart. You read a flow chart and then we will begin the discussion within a minute or two. Registration and dissolution of a firm. First of all, we'll understand the mode of effecting registration. How registration can be put into picture. How you can get the registration done. There are certain formalities. What are those formalities? And after compliance with those formalities, you are entitled to seek registration of your firm. Consequences of non-registration. Now, you are not required, I mean, there is no mandatory requirement to get the firm registered. Okay, to get the firm registered, like we discussed in the beginning, because firm or a partnership can come out of a oral contract as well. And when you have an oral contract, how can you get it registered? Okay, so when a firm can come out of oral contract as well, that means the registration of the firm is not mandatory. Okay, it is not mandatory that you should have a registration of the firm, but there are some privileges of getting the firm registered. So, when there are some privileges, some positive points of getting the firm registered, then there should be some consequences. Consequences means minus points of non registration as well, isn't it? So, we will read what will happen if your firm is not registered and what benefits you will get if your firm is registered. Then we will see dissolution of firm. How the firm could be dissolved. One very simple way is dissolution by the intervention of court. One party reaches to the court and court orders the dissolving of the firm. Okay, court will not automatically order the dissolving of the firm, but if court finds that dissolving is required, then it will dissolve. Other purpose is dissolving without the intervention of the court. That means you intercede, sit and you decide and partners settle it out. How can it be dissolved? There are four ways. Dissolution by an agreement. Okay, you have an agreement and as per that agreement now firm is dissolved. Dissolution by operation of law or compulsory dissolution. There may be some law which requires a firm to be dissolved, or there may be compulsory dissolution. Dissolution on happening of certain contingencies. Some events have happened which call for your dissolution. Dissolution by notice. Some partner has given a notice and your firm is now dissolved. First of all, understand registration of firms. Application for registration. When you want to get your firm registered, definitely you will have to make an application to someone. Whom you will make an application? When we are getting registration of something done, registration of a company, registration of firm, registration of birth, registration of death, registration of anything, you always go to a registrar. Okay, so in this case as well, there is a registrar who will register your firm. So registration of a firm may be effected anytime, even after you have got it. Like even you when you started firm, suppose in 2010, and you want it to be registered in 2015, then also it could be registered in 2015 as well. It is not required that you have to again set up a new firm in 2015 and register it. You can register an already running firm as well. Registration of a firm may be effected anytime by sending by post or delivering to the registrar of the area in which any place of business of the firm is situated. In which any place of the business of the firm is situated. Like if your firm is having 4 offices, in any of the offices, okay, any of the registrar who is sitting over the any of the office, you can send him by post or physically go and deliver it to him. Proposed to be situated a statement in the prescribed form. There's a prescribed form, okay, you can find it somewhere in the act. In that form you will fill the form, and with that form you will attach a fees. You will have to pay a fees, okay, and in that form you will have to fill these following details. Okay, you will have to pay some registration fees as well, because state is providing you facilities for registration. The state will charge some fees as well. Let us see what are these formalities which you have to comply in order to get your firm registered. The name of the firm, the place or the principal place of the business of the firm, the name or any other places where the firm carries on business, the date when each partner joined the firm. Okay, the names in full and permanent addresses of the partners, where they live, who they are, the duration of the firm, if the firm has any duration at all. Okay, if your firm has a duration, then the duration of the firm. Otherwise, you can just say that firm has no duration and it's a firm at will. Okay, it's a partnership at will, or it's a continuous partnership. Now, this statement shall be signed by all the partners or by their agents specifically authorized in this behalf, either themselves or some agent. Each person signing the statement shall also verify it in the manner prescribed. There is a manner in which you have to make a verification, you will make that verification. A firm name shall not contain any of the following words. The firm name should not contain these words: crown, emperor, empress, empire, imperial, king, queen, royal, or words expressing or implying the sanction, approval, of the patronage of the government, except when the state government signifies its consent to use such words as part of the firm name or by order in writing. Okay, so these are the names which you cannot usually have. Okay, but these initial words, crown, emperor, empress, empire, imperial, king, queen, royal, these are not very much relevant nowadays, and you can have a firm which uses the name crown, emperor, empress. But for the purpose of examination, you will have to write it that you cannot use, but you can really now use it because they have no practical purpose left nowadays, because this act goes back to 1932 and it's a cut copy paste version of the English Act. So in the England, you understand, even in the India, when India was a colony of English, then crown, empire, emperor, empress, imperial, king, queen, royal, these are the words used by the ruling family or the monarch. So when any firm had these words, then it used to mean that this is having the support of the government. So when something is having a support of the government, people trust it more easily than a normal firm. So you were not allowed to use these words. In England also, in England you still cannot use these words. But now, because we do not have such crown or emperor or king or queen, so you can use them. But now you cannot use in the government of India or the state of Tamil Nadu or the Gujarat or like these terms without the consent of the state, because it implies that you have a connection with the government. And when you state that you have a connection with the government, definitely you get a certain mileage over the other people, other firms. So in order to provide a level playing field and in order to prevent fraud and deception, you are not allowed to use state government's name. The registration of partnership is optional, and one partner cannot compel another partner to join in the registration of the firm. It is not essential that firm should be registered from the very beginning. When the partners decide to get the firm registered as per the provisions of Section 58 of Indian Partnership Act 1932, they have to file the statement in the prescribed form which we just discussed. When the registrar is satisfied that the above mentioned provisions have been complied with, he shall record an entry in the statement in the register called the registrar of firms and shall file the statement. He shall record. That means he is bound. Okay, if you have filled all the details in a legal manner, in whatever legal formalities there, if you have complied with them, then registrar has no such option. He has no option at all. He has no power. He cannot say no, I will not register. He is bound to register. He must register. He cannot deny registration to the firm. Subsequent alterations in the name, place, constitution, etc. of the firm that may occur during its continuance should also be registered. Okay, so when you have become a registered firm, so whatever big change is happening, okay, change of the office or some partner is coming in, going out, or name is being changed, then you have to intimate those alterations as well to the registrar, and you have to get that also changed in the register of the firm. Registration, Section 59. When the registrar is satisfied that the provisions of Section 58 have been duly complied with, he shall record an entry of the statement in a register called the Register of the Firms and shall file the statement. He shall do it. When the registrar is satisfied that the provisions have been complied, this is repetition. However, registration is deemed to be completed as soon as an application in the prescribed form with the prescribed fee, necessary details concerning the particular partnership is delivered to the registrar. It is deemed to be complete. Why? Because I just discussed, registrar does not have a power to deny registration or not to allow registration. He cannot do so if you have complied with the legal formalities. He really does not have much powers. The recording of an entry in the register of firm is a routine duty of registrar. That means he keeps on doing it every day. Registration may also be effected even after a suit has been filed by the firm, but in that case it is necessary to withdraw the suit first and get the firm registered and then file a fresh suit. So when you have filed a case, okay, when you are not registered, then you cannot file the case in the name of the firm because your firm is not registered. Okay, an unregistered firm cannot file the case in the name of the firm. It can file the case only in the name of partners personally. It cannot use a name because name is not registered. When the name is not registered, you are not having any legal identity. So when you are not having any legal identity, how can you use that name for filing a case in the court? So when you have filed the case in the court, you will, as an unregistered firm, you will file it in the name of partners individually. But even if during the case is going on, you want to get your firm registered, you can get the firm registered, but you will have to withdraw your suit. You will have to take back the suit and you will have to file the suit again in the name of the registered firm. Okay, in the name of registered firm. So it is always advisable to get the firm registered at the first instance only. Always start a business with a registered firm, otherwise tomorrow it will be difficult for you, because there are consequences which we will discuss as we proceed ahead with the chapter. Now, what are the consequences of non-registration of the firm? Section 69. Under the English law, the registration of firm is compulsory. Registration of the firm is compulsory in the English law, England. Therefore, there is a penalty for non-registration of firms. Okay, but the Indian Partnership Act does not make the registration of firms compulsory, nor does it impose any penalty for non-registration. However, under Section 69, non-registration of partnerships give rise to a number of disabilities which we shall presently discuss. But see, there is no compulsion. It is not mandatory to have a registered firm. In England, it is mandatory, but we are in India. India, it is not mandatory. But if you do not register, there are some disabilities, some disadvantages which will occur to you in the law. Okay, and by registering, you can evade or prevent those disabilities from coming to a partnership. Although registration of firm is not compulsory, yet the consequences or disabilities of non-registration have a persuasive pressure for their registration. These disabilities briefly are as follow. Now we will do what are the disabilities which will occur to a firm if it is unregistered. No suit in a civil court by firm or other co-partners against the third party. The firm or any other person on its behalf cannot bring an action against the third party for the breach of the contract entered into by the firm, unless the firm is registered and the persons suing are or have been shown in the register of the firm as partners in the firm. In other words, a registered firm can only file a case against a third party and the persons suing have been in the register of the firm as partners in the firm. That means you cannot go to the court. Okay, you cannot go to the court. You have opened up a firm's account. Okay, and someone has given you a check. Now the check has bounced. Now, when you do not have a registered firm, how can you become a partner of that firm? Then it will be difficult for you to file a case in the law. It will be extremely difficult. You cannot file a case. You will have to do all the dealings in the names of partners only if you are going with an unregistered firm. So, for all those dealings, your partners will have to file personal cases. You cannot use the firm's name. Okay, this is a very, very big disadvantage for non registration of the firm. Okay, and this is itself a sufficient reason for always having a registered firm. No relief to partners for set off claim. If an action is brought against the firm by third party, then neither the firm nor the partner can claim any set off if the suit be valued for more than 100 or pursue other proceedings to enforce the rights arising from any contract. Set off is a legal term. Set off is a legal term, but you understand it in the literary English manner. Setting off means clearing something against someone. I owe you 100 rupees. You owe me 40 rupees. Now, ultimately, what is there? Ultimately, I owe you now 60 rupees. What is this? It is that you have set off your 40 rupees against my 100 rupees. Okay, sorry. So I have set off these 40 rupees which you had to pay me against the 100 rupees which I have to pay you. So now I have to pay you only 60 rupees. This is called a balancing. We are setting off with each other. So now one person has filed a case against the firm. Okay, that firm owes me 1 lakh rupees. And firm says we'll set off 50,000 which he is supposed to pay. You cannot do that. Okay, you cannot set off the claim. Why? Because firm cannot go for any legal action without its registration. Okay, so virtually legally it is dead. So when legally it is dead, it cannot follow legal remedies. It will have to do all the actions in the name of partners only. Then only they can use their remedies in the law. Otherwise, they will be really handicapped. So they cannot even set off like this. A grieved partner cannot bring legal action against other partners or the firm. When you are not into a partnership, you cannot file a case against it. Okay. When your partnership firm is not registered, it is unregistered. Okay. It is not a legal entity at all. Okay. It is not alive in the law. So how can you file a case? It is non-existent. How can you file a case against a non-existent entity which does not exist at all? Plus, how can you file a case against other partner? Because when the entity is non-existing, how can someone be a partner of a non-existing entity? So everything will be deemed to be non-existent. Partners are non-existing, existing, firm is non-existing. Okay. So aggrieved partner cannot bring legal action against other partners or the firm. This is also another big disability. A partner of an unregistered firm or the other person on this behalf is precluded from bringing legal action against the firm or any person alleged to be or to have been a partner in the firm, but such a person may sue for dissolution of the firm or for the accounts and realization of his share in the firm's property where firm is dissolved. Okay, but if you have dissolved the firm, you can file a case for accounts or you can file a case for dissolution of the firm, but not otherwise. Okay, not otherwise. Third party can sue the firm. Now, this is, see the thing of the law. You cannot file a case against the third party in the name of the firm, but the third party can file a case in the name of the firm. Okay, this is, you know why? Because third party is not responsible for your non registration. You are responsible for your non registration. So, you cannot file a case as a firm, but the third party which is dealing with you and has some dealings and you have to pay something to third party is not responsible for your non registration, you are responsible. So the disability will come to the one who is guilty. You are guilty, your firm is guilty, so disability will come to you. Third party has no role to play here at all. So third party will definitely file case against the firm and you people will be liable as the partners. Non-registration of firm does not, however, affect the following rights. There are certain exceptions as well. It is not that non-registration will or legally kill the firm and you cannot have any right at all. You still shall have some rights. The right of third parties to sue the firm or any partner. That is third party's right. The right of partners to sue for dissolution of the firm or for the settlement of the accounts of a dissolved firm or for realization of the property of a dissolved firm. Okay, these rights you still will have. You can seek a dissolution of the firm or you can seek the accounts or you can seek the property of the dissolved firm. The power of an official assignee receiver of the court to release the property of the insolvent partner and to bring an action. Okay. The power of the court. Court can definitely have power of your above your firm. Court can automatically make sorry not automatically but court is empowered to make whatever order it wishes to against your firm in the law even if your firm is not registered. Okay, because disability is upon the firm and the partners, not upon the court. Court can never be a disable. The right to sue or claim a set off if the value of suit does not exceed 100 rupees. So if you are dealing with less than 100 rupees, then you can set it off. But will a firm deal in less than 100 rupees or will you go for a case for 100 rupees? No. But we see this 100 rupees here because this act was brought in 1932. That time 100 rupees would have been like 1 crore today. Okay. But we have not made changes in it with the times. So this 100 rupees still remain 100 and this purpose, this point has lost its relevance. It is not practical anymore. Nobody will file cases for 100 rupees. A and Company is registered as a partnership firm. Okay. I mean, it's a partnership firm, but they are calling their firm A and Company. Okay, it is not a company but a partnership firm. In 2015, with A, B, and C. In 2016, A dies. In 2017, B and C sue X in the name and on behalf of A and Company without fresh registration. Now, the first question for our consideration is whether the suit is maintainable. Okay, because there were three partners. A has died. In 2017, B and C file a case in the name of this firm A and Company only against X without seeking fresh registration. Now, first question is whether the suit is maintainable. Maintainable means whether they can do so, whether they can file the case. Now, let us see the answer. As regards the question whether in the case of a registered firm whose business was carried on after its dissolution by death of one of the party, a suit can be filed by the remaining partners in respect of any subsequent dealings or transactions without notifying to the registrar of firms. The changes in the constitution of the firm, it was decided that the remaining partners should sue in respect of such subsequent dealings or transactions, even though the firm was not registered again after such resolution and no notice of the partner was given to the firm. That means, yes, they can do so. Okay. The test applied in these cases was whether the plaintiff satisfied the only two requirements. There are only two requirements. Okay, the suit must be instituted by or on behalf of the firm which had been registered. The person suing had been shown as partner in the register of the firms. In view of this position of the law, the suit in this case by B and C against the X in the name and on behalf of A and Company is maintainable. That means you once get your firm registered and whatever change happen you have to intimate to the registrar, even if but somehow you do not intimate or notify to the registrar, then your firm will not automatically get dissolved if you have a clause of continuation of the firm. Okay, neither your registration will be cancelled, but if you were shown as a partner in the firm, then you can file a case. Now, in the example, what difference would it make if in 2017 B and C had taken a new partner D and then filed a suit against A without fresh registration? Now, what would have been the difference in the situation? Now, we have done a situation in which A has died, a partner has died, but now suppose they have taken a new partner. After the death of A, they have now added a new partner, but they have filed a case against X without making fresh registration. Now, in such situation, what would be the condition? Where a new partner is introduced, the fact is to be notified to the registrar, who shall make a record of notice in the entry relating to the firm in registrar's name. When new partner definitely comes in, you have to put his name. Okay, therefore, the firm cannot sue as D's new partner's name has not been entered in the register of firms. It was pointed out that in the second requirement, the phrase person suing means person in the sense of individuals whose name appear in the register as partners and who must be all partners in the firm at the date of the suit. Okay. Now he has to be a partner. Okay. XD cannot file a case. B and C can file a case. Okay. B and C can still file a case in the name of firm, but D cannot file. D's name has to be entered. Okay. D's name has to be entered. Now we go to dissolution of firm. How the firm can be dissolved. According to Section 39 of the Indian Partnership Act 1932, the dissolution of partnership between all partners of a firm is called the dissolution of firm. Okay. Dissolution, what is dissolution? Dissolution is dissolution, closing or shutting down of partnership between all partners. That is called dissolution. Okay, it is not one partner has retired or one has gone out or one has died that we call it a dissolution. No, when all partners go out of the partnership, it is called dissolution of the firm. Thus, the dissolution of firm means the discontinuation of the usual relation between all the partners of the firm. But when only one or more partners retires or become incapacitated from acting as a partner due to death, insolvency, or insanity, the partnership, i.e., The relationship between such partners and other is dissolved, but the rest may decide to continue. In such cases, there is in practice no dissolution of the firm. The particular partner goes out, but the remaining partners carry on the business of the firm. It is called dissolution of partnership. Okay. In case of dissolution of firm, it is not called dissolution of partnership. In the case of dissolution of the firm, on the other hand, the whole firm is dissolved. It's okay. 3 o'clock. The partnership terminates as between each and every partner of the firm. Okay. On dissolution, only dissolution is the term which means all partner have opted out of the partnership. Otherwise, no. Okay, if one have gone out, died, or something like this. Dissolution of firm versus dissolution of partnership. Okay. I'm sorry, this is a dissolution of partnership. When one particular partner goes out, it's a dissolution of partnership. But when the whole firm is dissolved, whole partners go out, it is called dissolution of firm. Let us understand the difference between. Okay, what is the difference between dissolution of firm and dissolution of partnership? Okay, what is the difference between dissolution of firm and dissolution of partnership? Basis of difference first is continuation of business. In dissolution of firm, it involves discontinuation of business in partnership. Okay, that means whole business has gone out, whole firm has dissolved. Dissolution of partnership means it does not affect the continuation of business. It involves only reconstitution of the firm. That means the earlier partnership has dissolved and some new partnership has come into picture. Earlier there were 5 people, now there are only 4, or now there are 6 people. Okay, that is called dissolution of partnership. But dissolution of firm is when all people have dissolved the firm. All partners have severed their relationship out of this partnership. All partners have gone out. Winding up. It involves winding up of the firm and requires realization of assets and settlement of liabilities. Because all partners have gone out, it is winding up of the firm. It involves only reconstitution and requires only re-evaluation of assets and liabilities of the firm. It is not winding up. It only is like you are paying someone's share. One partner share is out, other partner comes in. You are now again recalculating your assets and liabilities after what is left. Okay, after paying the share of the partner, whatever is left, now you are just recalculating it. Order of the court. A firm may be dissolved by the order of the court. Okay, court may order to dissolve the firm. But dissolution of partnership is not ordered by the court. Court will never say you send a partner out. Okay, this is up to your choice. Whom you people want to have a partner. Court does not have any issue with your partnerships, with your friendships. Scope. It necessarily involves dissolution of partnership. I mean, they are trying to say that dissolution of firm is a wider term and it includes dissolution of partnership. But dissolution of partnership does not automatically mean dissolution of firm. Okay, it is a narrow term, it's a wide term. Dissolution of firm automatically means there is a dissolution of partnership as well. But dissolution of partnership, outgoing of one partner, does not automatically mean dissolution of firm. Final closure of the books. It involves final closure of the books of the firm. Books of the firm are finally closed. No further business is going to take place because the whole firm has gone out. This is dissolution of firm. Dissolution of partnership, on the other hand, does not involve final closure of the books. There is no final shutdown of the firm. Now, mode of the dissolution of the firm. Now, we are talking about whole firm, not partnership. How the firm will be dissolved. All partners go out. Okay, we are discussing that situation now. The dissolution of partnership firm may be in any of the following ways. Dissolution without the order of the court or voluntary dissolution. Okay, we are discussing we are discussing we discussed that in this heading there are four kind of further declassification. So we'll now do all those parts. Okay, four types. First case is voluntary dissolution. Okay, that is without the order of the court. Dissolution by agreement. A firm may be dissolved with the consent of all the partners or in accordance with a contract between the partners. Okay, so now five, six partners are there. They come, they decide that we should dissolve the firm. Then the firm can be dissolved with the consent of all the partners. Okay, or in accordance with the agreement. If the agreement has provided that the firm shall be dissolved on such date, if it was a fixed firm, okay, the firm had to continue business only for 3 years. After 3 years, the firm will automatically dissolve unless you decide to keep it alive. Section 40 gives right to the partners to dissolve the partnership by agreement with the consent of all the partners or in accordance with the contract between the partners. Contract between the partner means contract already made. Compulsory dissolution, that is section 41. Okay, it is given in 40 to 41. This is section 40, this is section 41. A firm is compulsorily dissolved by the happening of any event which makes it unlawful for the business of the firm to be carried on or for the partners to carry it on in partnerships, providing that when more than one separate adventure or undertaking is carried on by the firm, the illegality of one or more shall not itself cause the dissolution of firm in respect of its lawful adventure and undertaking. There was a firm for a particular adventure or a particular trade, like for suppose some chemical, they were dealing in that chemical. Now there is a law and it says anyone dealing with this chemical is prohibited. Or some suppose there was a liquor selling organization in Bihar, but later on Bihar says you are prohibited to have, hold, sell, do anything with the liquor. So now the automatically the object of the partnership has become unlawful, so the partnership firm will come to an end. Okay, but if it has more than one object, two, three, four object or nature of business, liquor as well as real estate as well as sports industry. So just because one portion of it has become illegal, they will stop doing business in that, but other businesses are still open and they can carry on their business. So one illegality of one nature of the business will not make the whole firm dissolve if it has more than one nature of the business. But if it has exclusively only one nature of the business, then on becoming of that nature, that business illegal, the firm will automatically be dissolved. Example: a firm is carrying on the business of trading a particular chemical and a law is passed which bans on the trading of such a particular chemical. The business of the firm becomes unlawful and so the firm will have to be compulsorily dissolved. That is dissolution by compulsion. Dissolution on happening of certain contingencies. Contingencies are events, okay, which may or may not happen. Subject to contract between partners, the firm can be dissolved on happening of any of the following contingencies. Where the firm is constituted for a fixed term on the expiry of that term. We discussed that firm can be a time limited firm. That firm will continue for 5 years. After the expiry of 5 years, the firm will be dissolved. Where the firm is constituted to carry out one or more adventures or undertaking done by completion of thereof. Like we discussed that Government of India and Government of Tamil Nadu come together for completion of a bullet train project between Tamil Nadu or Chennai or between Chennai or Madurai. And after the completion of the project, automatically the partnership, the firm would come to an end by death of a partner. In case of a two-member partnership firm, if there are only two members, by death of the partner, the firm will automatically come to an end and the firm will be dissolved if there are only two partners. But if there are more than two partners and there is a contract that upon death the firm shall not be dissolved, then there will not be a dissolution of firm, it will only be a dissolution of partnership and the firm will continue. By the adjudication of partner as an insolvent. Okay. when the partner has been adjudged insolvent. But these two, these below two, are applicable only when there is a two partners firm. Okay, only when there are only two partners in the firm. If there are more than two partners, then death or insolvency may not always bring an end to the firm. It may definitely bring an end to the partnership, but not to the firm, and firm may continue somehow. Dissolution by notice of partnership at will. We discussed a case that the partnerships at will, that means at the choice, can be terminated anytime because you do not have any further choice, you do not have any further will. Okay, so where the partnership is at will, the firm may be dissolved by any partner giving notice and writing to all the other partners of his intention to dissolve the firm. If the date is mentioned, the firm is dissolved as from the date mentioned in the notice as the date of dissolution, or if no date is so mentioned, from the date of the communication of notice. Okay. Dissolution by the court. Okay, now this is the last leg. Why a court can order the dissolution of a firm. Court may, at the suit of a partner, court may sometimes dissolve the firm. Okay, we are still having a lot of dissolution of a firm. Court may, at the suit of the partner, dissolve a firm on any of the following ground. At the suit of whom? At the suit of partner. That means only a partner can seek dissolution and no third party. Insanity or unsoundness of mind. Okay, madness. When a partner, not a sleeping partner. Okay, why not a sleeping partner? Because okay, only for active partner it is. Where a partner has become unsound mind, the court may dissolve the firm on a suit of the other partners or by the next friend of the insane partner. Temporary sickness is no ground for dissolution of firm. Madness is the madness. Okay, insanity. Someone has lost his senses, lost his mind. Doctor has certified that. We are not talking about a situation in which someone has become temporarily sick. Okay, sickness is not a ground. Unsoundness or insanity has to be of permanent nature. Permanent incapacity. When a partner, other than the partner's twin, other than the partner who has filed the case, has become in any way permanently incapable of performing his duties as partner, then the court may dissolve the firm. Such permanent incapacity may be result from physical disability or illness. Okay, he has contracted such a disease that he cannot come, or he has become disabled, he has lost his legs or feet, his legs or hands or something like this. Okay, and he is permanently incapable of discharging the duties, then other partner can file the case. Okay, misconduct where a partner other than the partner's twin, okay, where the partner other than the partner's twin, it means that the one who is filing a case complaining misconduct or incapacity of some other partner, not his own. Okay, it is not that some partner is himself going to the court stating that I am incapable, I have committed misconduct or I have become mad. Okay, where a partner other than the partner's twin is guilty of conduct which is likely to affect prejudicially the carrying on of a business, the court may order for dissolution of the firm by giving regard to the nature of business. If a partner has done something which will have an impact over the firm, suppose he is found committing act of corruption or some moral turpitude, okay, or he is found to be doing some found guilty of some criminal offense which will bring bad reputation to the firm, okay, or he has committed cheating in the firm's accounts, he has embezzled the firm's money or something like this. Okay, Then other partners may approach the court seeking dissolution of the firm. It is not necessary that misconduct must relate to the conduct of business. Okay, it is not necessary that misconduct should be in relation to the business. If he has committed any crime outside, then also. The important point is the adverse effect of the misconduct on the business. In each case, nature of the business will decide whether an act is misconduct or not. Now, what is misconduct shall be decided on case to case basis. Persistent breach of an agreement. Where a partner other than the partner suing willfully or persistently commits breach of agreements relating to the management of the affairs of the firms or conduct of its business, or otherwise so conduct himself in matters relating to the business that it is not reasonably practicable for other partners to carry on the business in partnership with him, then the court may dissolve the firm at the instance of other partners. Okay. Now he is committing constant breach of the agreement. Four partners came to a partnership with an agreement and there were some duties given to each other. Now he is not fulfilling his duties and not letting other also fulfill the duties. In such cases, he is committing regular breach of contract. So it is not practical or not easy to work with him. So in this case, partners may go to the court and seek dissolution of the firm. Embezzlement, he has committed some corruption in the firm. He has misused the money of the firm. Keeping erroneous accounts. He is keeping fake accounts, fabricated accounts. He is not keeping true accounts. Holding more cash than allowed. Suppose there is some principle of the firm that you have to hold this much cash only. He is always holding more than the cash allowed. Refusal to show accounts despite repeated requests. He is in charge of the accounts but he is not disclosing the accounts. Okay. In such cases, that is called a persistent breach of agreement and partners can sue him for the dissolution. If one of the partners keeps erroneous accounts and omits to enter receipts, or if there is continued quarrels between the partners, or there is such a state of things that destroys the mutual confidence of partners, the court may order for dissolution of the firm. Transfer of interest. Where a partner other than the partner suing has transferred the whole of his interest in the firm to a third party, or has allowed his share to be charged or sold by the court in recovery of the areas of land revenue, the court may dissolve the firm at the instance of any other partner when his interest has been transferred either by himself or by the court. Continuous or perpetual losses. This is an unfortunate situation where the business of the firm cannot be carried on except at the loss in future also. When there is no profit at all, the firm is only making losses and losses and losses. Then why would someone continue with a firm which is making no profit at all? Because we discussed the firm is ultimate aim of the firm is to make profit, but you are not able to fulfill your aim, you are making losses, then how long can you continue with the losses? So you can go to the court. Just and equitable grounds. Just and equitable grounds means any other grounds which is not mentioned here, and it appears fair. Okay, any other ground which is not mentioned. Okay, that it is fair to dissolve the firm. The ground is such. Some are the cases. These are only the examples. It is not that we are again writing cases that these are only the just and equitable grounds. Just and equitable grounds could be anything. These are some examples. Deadlock in the management. Okay, there is a deadlock. There are 10 partners. 5 and 5 are split. 5 are saying yes. 5 are saying no. So now, and it cannot be resolved. Then it is better to shut down the firm where the partners are not in talking terms between them. When the partners have such an issue with each other, there is a quarrel, they are not talking to each other. So definitely, firm cannot commence business when partners are not having harmony between themselves. Loss of substratum, okay, when you don't have any capital or the property left with you. Gambling by the property by a partner on stock exchange. A partner has played a gamble with the stock exchange and lost money. So now this is the flow chart of what we just discussed, how the firm can be dissolved without the order of the court. Okay, without the order of the court, how it could be dissolved by mutual agreement. We discussed compulsory dissolution happening of certain event or by notice. And by the order of the court, when there is insanity, misconduct, permanent incapacity is there, persistent breach of agreement, transfer of interest, continuous loss, just and equitable grounds. Now, in the next lecture, this lecture is on its end. We'll continue with the consequences of dissolution.